Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Good morning. It is a beautiful spring day here, but boy, are the allergies getting to my eyes. I'm just a big waterworks. Anyway, quick review on some questions I get a lot, both from my clients and from people that just reach out to me. Why am I getting a request for a mental consultative examination from the SSA and not a physical? My problems are physical. That's one of the questions. The reason is there is something in the application or the function report where you suggest maybe you have reduced concentration, reduced focus. Maybe you feel like your memory is not like it was. Maybe you're not retaining things. It could be as simple as that, or it could be something more significant. You put anxiety in one of your impairments. Either way, even the most garden variety kind of mental health effects that we have, it can be from our impairments causing it, meaning our physical, or it can be from our personal life. It can be from anything. It can be a blatant disorder or just a mild garden variety. All the time. I mean, I rarely ever see a client who does not suffer some version of the above by the time they're filing for Social Security disability. It's unfortunate. I would say I see. I think if you read any literature out there, you'll find that most everyone by the time they're 40s, 50s, or above, if not way earlier now, apparently have some sort of these effects. Whether you want to call them a disorder or not doesn't really matter for our purposes here, but particularly for the over 50 crowd, you must know that the importance of medically illustrating that you have these minute limitations, mild limitations, mild to moderate, nothing more than that, is critical to either prevailing on your case or not prevailing on your case. Now, we go into a little bit of this elsewhere, I think, but to sum it up quickly, you have to prove you cannot do your past relevant work. If you were not an unskilled worker in your past relevant time period, and as you know from a recent video, feel free to ask about it if you in the comments below if you don't know where to find it. They are changing the past relevant work look back period from 15 years to 5 years, which is a phenomenal change. Phenomenal for claimants, unbelievably phenomenal. It was so shocking to me because we never normally see good things happen. So if you in your past relevant work had anything other than skilled work, you without it's likely that without being willing to verify the slight reduction in concentration, focus, increase in distractibility, worrying too much, et cetera, without being able to show that, you are going to, pardon me, probably lose your case because they can say in many of these past relevant work experiences that those skills, or some of them, can transfer to a job you could physically do, even if you can't physically do that job you had. A desk job, for instance. There are unskilled desk jobs. There are semi-skilled desk jobs. And if you come from a semi-skilled or skilled background, there you go. You just lost your case at step 4. The first part of step 4, you can do your past relevant work potentially as you performed it, or as is generally performed in the national economy, even if you didn't perform it that way. So the influence of a reduction in your mental capacity to transfer skills that would be required due to that, the anxiety, the distractibility, the lack of concentration, It could be tearfulness, there's a variety of things. That is what is going to prevent you from losing oftentimes at step 4. So when and this adds on, guys, that when you are doing your application, if you're pro se, or if you have an attorney, but you haven't told them about it, and you do experience slight, even if you're not treating at this point, I suggest you look into that as well. Start talking to your PCP, maybe get a counselor. It's going to want to be, you're going to want that to be in your claim if it is true. Because if it's not, they're not going to send you to a CE. And by the way, let's go into the fact that they send you to a CE because you either mention that you have these issues and you're not treating, so there's no evidence, and they're giving you the opportunity to present it as such to their provider, or you do have records, but they don't. You could have one of those really crappy providers, mental health providers, who don't say anything. It makes you think they're sleeping while you're talking during your sessions, probably. There are some providers that do not provide any of the details they're supposed to. They take we have a video on this, they misunderstand the carve out for psychotherapy records to include the mental status examination that every provider should be doing quickly with every client at every session. Appearance, speech pattern, mood, all that, the rundown. But a lot of them don't do that. Is it laziness? They'd probably say otherwise if they're listening. No, it's not lazy. So anyway, they confuse those competent records with psychotherapy notes, which are completely different. And the MSCs are not carved out, nor are the start and end times of the session, when you had sessions, what the diagnosis was you were getting treatment for, and what kind of treatment he was giving you. All that stuff should be there. But in any event, if you have one of those incompetent recording providers, that would be another reason why the SSA, who needs to know if you have a reduction in these concentration skills, if you want to call them skills, or not. That's their job, to give you that opportunity. And they actually provide, whether you like them or not, a consultative examination for that purpose. So it's not to help the SSA per se. It is to fulfill the requirement of giving you that opportunity. What you do with the opportunity is on you. We do have, I think there are 2 videos telling you some of the things to look out for, to be aware of, to not forget to do, to have a more thorough and accurate mental CE. So feel free to look them up. If I can, I'll attach them at the end. But anyway, that is the biggest reason why you are being asked to go to a mental CE exam and not a physical CE exam. The reason for the not of the physical CE exam is because the SSA is convinced they have enough evidence to determine yay or nay the extent of your physical limitations. I would say they believe they have enough to have their medical expert develop an RFC, residual functional capacity, on you, and they don't need any more. They got enough from your records. That is not a signal that you won. It just means they have enough to quantify your residual functional capacity, which is one of the steps they have to do. As soon as they realize you don't meet a listing based on your medicals, then they have to quantify, well, what can you still do despite these clearly severe impairments? And then after that, what jobs would be available. So there is that, guys. I hope that answered some of those questions. And the other question is, do I have to go? Mm-hmm. Sure do. If you didn't go and you were my client, you wouldn't be my client anymore. Does that mean that emergent things cannot occur where you can't show up? It does. It will be rescheduled, perhaps once if you're lucky. If not, they don't reschedule, and they certainly don't tend to do it a second time. And you could almost guarantee you're going to have a denial. Almost. So don't hurt yourself. Go through the process. I know it's annoying for all of us. I'll talk to you later. Bye.